Hi, Kaylee, thanks so much for that. Right now, we're going to welcome on Matthew Leffler, our armchair attorney here joining us. Matt, thanks so much for joining us this morning.
Thank you for having me, Anthony. How are you doing today?
Doing well in yourself?
I'm living the dream. It's Monday. It's getting close to the end of the year. It's fantastic. Thank you for having me on the program today.
Of course, always a pleasure having you on. And today we get to chat about some employment stuff happening with really UPS, FedEx, some different types of classifications of contracting, and then Amazon is thrown in the mix as well. What can you tell us about it?
Well, we just had a lawsuit filed just a couple days ago against FedEx Ground. One of their independent service providers has sued them under some really interesting federal statutes, including RICO, regarding the classification of them as independent contractors. Look, if you've been following AB5, this court case right now, this 99-page complaint, is a masterclass in how you defend yourself when it comes to making the structures to say someone is a contractor versus an employee. The facts are bonkers. There are over 100,000 trucks operated by independent service providers among 6,000 or 7,000 different companies. This is how FedEx Ground gets packages to your home through contractors. And now we're back in litigation. In this case, this type of litigation has been going on for decades.
So, Matt, let's break out some details of this case because it is really fascinating and it has, as you mentioned, some really big-time implications for how FedEx does its business, but also could be those broader legal implications for how our independent contractor cases are handled down the future. And this doesn't directly involve that AB5 legislation that is passed in California, but it could be kind of that connecting piece, right? So what is this case saying? Who's it against, or who is it between, and what could those possible outcomes be?
Yeah, so let's take the Wayback Machine. Before deregulation, there was a company called Roadway, and that company spun off a division called Roadway Package Systems. That eventually became what we call FedEx Ground. So FedEx Ground was the kind of the initial innovator of the independent contractor model. How do you make somebody behave like an employee, but keep them at arm's length, where they're paying their own health insurance, their own maintenance costs, their own fuel costs? And Ground has been litigating these cases every single year for many, many years, decades even. So AB5 is that statute in California. FedEx complies. FedEx Ground complies 100% with what AB5 requires. And that's why they're not part of this AB5 stuff we see so often. This case is different. This case is about an independent service provider who is unhappy with the deal that they were given. So let's take a little bit of the nuance here. So independent service providers are the folks that deliver things to your house. The person who owns that route, that CSA, that's what they call this, the route itself, that may be owned by that contractor. It may be owned by a third party. There's different intermediaries that are affected here. And this service provider is saying, hey, you guys have defrauded me. You misrepresented what this deal is all about. What I will mention is in the first couple pages of this 99-page complaint is a disclaimer saying, we understand there's an arbitration clause. We don't think we're bound by the arbitration clause. That's why we see claims of fraud and RICO, because those things can get around the arbitration clause. Typically, these things get pulled out of court into a quiet room where people negotiate and deals are done. This is not an arbitration now, but it may be an arbitration before the end of the next couple weeks.
And Matt, that was going to be my next question, is what this timeline looks like moving forward. Sounds like it can be something that could be resoluted over the next, find resolution over the next couple of weeks here. What does this kind of have to do with the pathway that Amazon might take moving forward?
So Amazon came to the business and they said, which model makes the most sense for us? A heavily unionized, we own all the trucks, we own all the employees like UPS? Or do we do something like FedEx Ground, where we have very little liability in the trucks, very little liability ultimately over the employees? And of course, Amazon went with the model that FedEx pioneered. So what we're seeing here is, can these independent contractors find actual places to litigate outside of binding arbitration? And if they're able to do that, that's really interesting for the Amazon contractors. If this could get to a class action kind of level, that's a very long roadmap. That's a very long litigation and incredibly expensive. My expectation, looking at the complaints so far, the claims we have are fraud and negligent misrepresentation, the RICO thing that's in there. A lot of these I don't think have a ton of meat on them. Like when you're a contractor going into FedEx, you have access to everything. You get to see a lot of financial information. You can talk to other dedicated service providers. And to say that you didn't understand the deal you struck is hard to argue in this day and age. Again, FedEx has been litigating these cases for decades. It's not like their first time in the rodeo. First time for a RICO. It's very interesting to see the RICO, but ultimately, I think we're going to see FedEx come back with a motion to dismiss and then a motion to move this to arbitration.
So, Matt, let's go ahead and talk about kind of those overreaching aspects or overreaching rulings that this could have going forward. Does the determination of this case, does that have any bearing on what the independent contractor, I guess, landscape could look like from a legal perspective going forward, just depending on how it ends up?
I think that's an interesting question. I don't think it does, right? So FedEx Ground knows the rules to say who's a contractor and who is an employee. They're very careful with these things. What we see here is ultimately a provider saying, I can't get out of the normal ways. I can't sue you for misclassification. That's not going to help me. I'm going to get stuck in arbitration. I'm going to bring these criminal things. And I'm going to say FedEx Ground is a criminal conspiracy that's out there tricking people to do business with them, that we're being coerced into signing contracts. Like the fact that we have to have FedEx Ground branded logos on our boxes or on our trucks. That's an incentive. It's not being forced upon you. So what I look at is if you want to comply with AB5, you want to understand this battle between contractors and employees, FedEx Ground has mastered this. Now they get sued all the time. They always get sued because they're the biggest one out there. They have 6,000 or 7,000 providers in their network. But ultimately, those 6,000 or 7,000 people are making money. They're doing a business deal with FedEx or with the intermediary who owns the route. And if you're trying to say, what does the future look like for employee classification, FedEx has mastered this. I mean, they are the market leader when it comes to making sure that we're at an arm's length transaction. And this litigation is bringing a bunch of other stuff, trying to find some way to pull this out of arbitration and put it into a courtroom where we could all learn about the practices of FedEx. But the reality is, I don't think it stands. I don't think it makes it very far ultimately, but it does make a lot of news, which is an interesting case.
So, of course, the last time that FedEx faced a really kind of public battle over independent contractors was a situation with Spencer Patton that happened last year. And those allegations that he was spreading false and untrue rumors about the company to drive business to his smaller business. And that kind of shook out in the courts as well. Do you think, I don't know, this is very much speculation, but do you think that there's any maybe ties here between someone who watched the Spencer Patton case unfold, who says, okay, I'm also a disgruntled independent contractor. Instead of potentially being sued by the company for going and voicing my concerns, let me now bring a suit forward and have that shake out in arbitration instead?
I think that's an interesting point. Ultimately, I think when people are in these deals, their livelihoods are at stake. Dedicated service providers or independent service providers are trying to make a living for their families. And if they lose those routes, if they lose what they've invested into this thing, they get very unhappy. They get very frustrated. And there's not a lot of recourses. Now, those limitations on recourses are in the contract documents. You get to understand what your rights are under the agreement. And when you walk away, you might have a case of really sour grapes. And one of the ways you can go back at somebody is talk to a lawyer and figure out a claim you can throw against the corporation. And FedEx has been, again, we've been doing this for at least 30 years in terms of litigation of classification versus, being an employee. And ultimately, FedEx has been successful. Every big company that's looking to find ways to classify someone as a contractor, they look at what Ground has done. They look at the legal pavement they have put in place through California and litigation across the country. So I think where there might be some level of coordination among people, potentially, maybe in a subreddit, they're talking about how they don't like the big bosses. But ultimately, when you lose your business or you lose your routes, you try and say, how can I come back? What else can I do? And this case was to file a case against FedEx, asserting a bunch of things like fraud and misrepresentation and RICO and criminal behavior and unfair competition. And ultimately, this is what happens when you have a deregulated industry with a lot of people who can get in business and move packages for FedEx.
It's only going to be interesting to see how all of this plays out. Matt, thanks so much for joining us. For those that want to get more of your content or follow you, how can they do that?
Hey, find me on Twitter, Armchair Addy, or find me on LinkedIn. Thank you for always having me here. I love to break down these legal topics. This FedEx case is fascinating. It's 100 pages. We'll see a lot more come out of it, and we expect FedEx's response probably in the next month, maybe 2 months, maybe sooner. So we'll keep posted as that develops.